Good evening everyone, welcome to BAJIRAO IAS Academy, the Hindu News Analysis. Today is 4th September 2025 and today we have some very important topics for the discussion. And all these topics, we will try and analyze them in a very detailed and in-depth manner so that this discussion will be helpful for your prelims and mains examination. So without any further delay, let's get into the discussion and let's understand these topics in a very detailed way. So the first topic, this is very important topic and we have been discussing this topic several times. And in fact, this topic is about the governors sitting on the bills passed by the state legislative assemblies for an indefinite period of time. Now yesterday we have discussed about Article 200 of the Indian Constitution, because Article 200 of the Indian Constitution says that whenever a state legislative assembly passes a bill, the governor would have the following options, because the bill would be sent to the governor for his or her assent. So therefore, before governor, he would have certain options. Now what are the options? The first option is he may give his assent to the bill. Right, so he may give his assent to the bill, and the second option is he may withhold his assent to the bill. He may also withhold his assent to the bill, and third, he may send the bill for the reconsideration of the state legislative assembly. So he may even send the bill for the reconsideration of the state legislative assembly. And the fourth option is that he may reserve the bill for the consideration of the president as well. So therefore, the governor would have four options under Article 200 of the Indian Constitution. Now, what is the problem with Article 200? So the problem is that Article 200 has never mentioned any timeline within which the governor must give his or her assent to the bills. So there is no mention of timeline in Article 200. And because of this reason, what has been happening in certain states which are being ruled by the opposition political parties, governors have been sitting on the bills passed by the state legislative assemblies for an indefinite period of time. And this is what has happened in the state of Tamil Nadu. In Tamil Nadu, the governor has not given assent to as many as 8 bills. So in response to this, the Tamil Nadu state government has approached the Supreme Court. Now the Supreme Court has mandated that the governor must give his assent to the bills within 3 months. So the governor must give his assent to the 3 bills, right? So therefore, this timeline has been contested by the president under Article 143 Clause 1 of the Indian Constitution. Now, the president actually questioned whether judiciary can really dictate the terms for the executive. Right, so this is the main question that the president has asked to judiciary under Article 143 of Indian Constitution. So this falls part of the advisory jurisdiction of the president or of the Supreme Court. Right, so I hope you have understood the whole background and the context of this topic. So let's understand this. First of all, this has been given in the Hindu newspaper and this is very important for prelims and mains examination as well. Right? So the Constitution Bench of the Supreme Court. So what is a Constitution Bench? A bench of the Supreme Court which constitutes more than 5 judges is known as a Constitution Bench. Now, Constitution Bench is generally constituted to hear the larger matters which actually involve the constitutional provisions. Right? So the Constitution Bench of the Supreme Court has been hearing the presidential reference under Article 143 Clause 1 of the Indian Constitution. So this 143 Clause 1 of the Indian Constitution, so the president has sought the opinion of the Supreme Court whether judiciary can really interfere in the working or the functioning of the executive. Can judiciary really set the timelines for the executive. So this is what the president has asked the judiciary under this presidential reference of article 143 clause 1. Right? So we all knew that the governors have been not giving assent to the bills. So therefore, because of this reason, the Supreme Court has come up with this particular judgment setting timelines. Right? So we'll understand, this particular case examines whether the timelines which are established by the Supreme Court, right? So these timelines are not just applicable for the president, but they are also applicable for the governor, right? So they will be applicable for both governor and the president, right? For example, imagine in case the governor gives his assent to the bills, so he must give assent to the bill within 1 month. So in case he is not giving assent to the bill beyond 1 month, so he must either give his assent to the bill, reconsider the bill for this, send the bill for the reconsideration of the state legislative assembly, or he can reserve the bill for the consideration of the president. So these things must happen within 3 months. Right? So therefore, this particular case, the Supreme Court has set timelines for giving assent to the bills to president and governor without amending the Indian Constitution. Right? So this will be the larger question that needs to be addressed here. So let's understand the core arguments in the presidential reference hearing. So what are the core arguments in the presidential reference hearing? So in fact, this is the same scenario in the state of West Bengal as well. So West Bengal government has argued that governors cannot examine a bill's legislative competence because governors don't have the right and expertise to examine bill's legislative competence. Rather, it is judiciary's work to look into or examine a bill's legislative competence. So this is what the West Bengal government's argument, because what governors have been doing, so they are examining the legislative competence of a particular bill, and they are not giving assent to those bills. They have been showing reasons that these bills are incompetent, they are violation of the constitutional provisions. But the West Bengal government has been contesting that this is the responsibility of the judiciary but not the governor, right? So therefore, this is not that, this is a very important argument that has to be kept in mind. Now, Kapil Sibal, an advocate who has been advocating for the state of West Bengal, he emphasized that governors who are withholding bills for an indefinite period of time, they actually make constitution unworkable, because the constitution has provided for a specific mechanism. But here what has been happening, governors are not giving assent to the bills. So therefore, overall what they are doing the constitution unworkable, and thereby ultimately leading to delaying the crucial legislation. And in fact, the members in the legislature, they make laws on behalf of the citizens, right? So in fact, they are the elected representative. Now, governor is not an elected representative. They are just an appointed representative of the center. But what they are doing, they are stalling the governance process by not giving assent to the bills, and that has been contested by the opposition ruled states. And the advocate of the state of West Bengal, so he even stressed that both president and governors are not real heads, right? So they are just titular heads, they are not real heads, and in fact the government is elected by the people. So the chief minister is the real head in the state, and prime minister will be the real head. However, president and governor are not real heads, they are just titular heads, and cabinet decisions must prevail under the principle of collective responsibility. Now, in fact, it is not the decisions of the governor, rather the decisions of the cabinet should prevail. The decisions of the cabinet should prevail. Why? Because cabinet constitutes individuals who are directly elected by the people, right? So they are also collectively responsible to the legislative assembly, and because of this reason the cabinet decisions must prevail, not the decisions of the governor. Now, an advocate for the state of Himachal Pradesh, so he even underlined the principle of separation of powers. So I hope all of you are aware about the separation of powers. We have three organs or branches of the government. So executive, judiciary, and the legislature. Right? So these are the three essential branches of any government. Right? So separation of powers is a principle which has been part of the basic structure doctrine. Every branch of the government have their own powers, their own functions. So one branch of the government should not excessively interfere in the functioning of the other branch of the government, is what is called as the separation of powers. And in fact, so he mentioned that this separation of powers principle is a foundation principle of the Indian Constitution, and it also forms part of the basic structure doctrine. Now, in fact, as per the separation of powers principle, so lawmaking solely rests on the legislature and interpretation rests with the judiciary. So legislature make laws and those laws will be interpreted by the judiciary as per the separation of powers. Now also understand, in India we have no strict separation of powers, rather we have checks and balances. And in fact, the Supreme Court has also raised concerns that fixing timelines, for example, the president and governor, they must give assent to the bills within 3 months. So this is the timeline, because the original article 200 has not provided any timelines for the governor and the president to give assent within that particular timeline. So therefore the Supreme Court is concerned that putting timelines or fixing timelines amounts to amending the constitution, right? However, Kapil Sibal for the state of West Bengal, so he clarified that it only ensures constitutional machinery functions as smoothly as possible if there are timelines for the president and the governor to give assent to the bills, right? So let's understand some federal concerns and the way forward as well. So what federal concerns we actually have in this context? Now, senior advocate Kapil Sibal, so he cautioned that governors who have been sitting on the bills passed by the state legislature for an indefinite period of time, so they erode the autonomy of the states under the federal structure, right? So they actually erode autonomy, because the constitution has provided for the states with their own set of government, right? A governor and the council of ministers, the legislature, judiciary, executive, right? So he advocated that if governors sitting on those bills for an indefinite period of time, so it possibly erode the autonomy of the states, and it also go against the federal principles, right? So it also goes against the federal principles, right? So ultimately it affects the overall functioning of the state governments. And in fact, through making governors not giving assent to the bills, the center has been indirectly controlling or undermining the cabinet form of government at the level of states, right? Because the governors have been delaying the bills, they're not giving assent to the bills. So ultimately the center has been undermining the cabinet form of government through the governors, because these governors are appointed by the president on the recommendations of the council of ministers. And in fact, he also insisted that the constitution is a living document. So that means to adopt new realities without diluting the state rights as well. However, Chief Justice of India B.R. Gawai, so Gawai led bench is weighing arguments that balances federalism, separation of powers, and the constitutional functionality as well, so that this debate can be settled in a much more peaceful manner. And whether timelines can be fixed to give assent to the bills. So if there are proper timelines for giving assent to the bills, so that makes states more and more autonomous, and the federal principles are also respected. It will not amount to undermining the cabinet form of government at the center. So but make sure that there will be no tussle between the elected government and the governor at the level of state, and this issue need an amicable settlement. So the next important topic is, should reservations exceed the 50% cap? Should reservations exceed 50% cap? Now, if we talk about this 50% cap, we all knew that in 1992, Indira Sonai judgment, the Supreme Court has set a cap. So reservations in India should not breach 50% cap. This is what the Supreme Court has set. So however, the 103rd constitutional amendment has provided 10% reservation for the economically weaker sections. However, it breaches the 50% cap set by the Supreme Court in Indira Sonai judgment. However, the Supreme Court has declared that this 103rd Constitutional Amendment Act is valid. It is not violation of the basic structure, and it is not violation of the constitutional provisions. Right? So therefore, let's understand in states like Maharashtra, Andhra Pradesh, Gujarat, Haryana, so there are number of communities. So those communities are also known as socially and economically progressive communities. So they are demanding the reservations. So one major example is the Maratha community from the state of Maharashtra has been demanding the OBC status or reservations for the Maratha community. So let's understand this. So should reservations exceed the 50% cap? So let's try and understand this. So Maharashtra reservation demand, in the state of Maharashtra, right? So in the state of Maharashtra, Marathas have been demanding that they should be given reservation. So firstly. Secondly, in Bihar, opposition political parties have been proposing that this reservation should be extended up to 85%. Right? So as of now, the cap is just 50%, but in states like Bihar, the opposition political parties have been asking that the reservation cap should extend up to 85%. Now, all these things that have been taking place, so they have reignited debates whether reservations can legally and practically exceed this 50% ceiling. So can we give reservation more than 50%? So this is the main debate, so around which our discussion is centered. Now, in fact, the Supreme Court's recent notice on applying for the creamy layer principle of scheduled castes and scheduled tribes, so it has further deepened the debate on reservation policies in India. Now, as of now, only the other backward classes have this creamy layer criteria based on 8 lakh rupees of income. So within OBCs, if anyone's family income exceeds 8 lakh rupees per annum, so they would be considered as a creamy layer category. However, the very same creamy layer category is not applicable for scheduled caste and scheduled tribes. But recently the Supreme Court has held that this creamy layer criteria should be extended to both scheduled caste and scheduled tribes. Now, all these developments that have been taking place, so they have brought the issue of reservation in India to the forefront of national discourse. So obviously it is true. So should the reservation be extended to 50%? Should the creamy layer be extended to scheduled castes, scheduled tribes? Should other communities be given the reservation? So there are number of issues, right? So these are multiple developments. They have brought the issue of reservation to the forefront of national discourse, particularly in the light of ongoing Maratha reservation issue. And we will also understand the implications for the broader framework of affirmative action in the country. Now, what exactly is affirmative action? So if I talk about affirmative action, so this is positive discrimination towards a particular community, a particular group of people, because of the historical injustice that they have suffered. It is very important to show positive discrimination towards this particular group of people, so which is called as the affirmative action. So in India, the reservation policy is considered as a form of affirmative action. So let's understand the constitutional provisions on equality and reservation. So we almost come across all these important provisions with respect to reservations. So for example, Article 15 and Article 16. So both Article 15 and Article 16, they are part of right to equality. So they guarantee right to equality of opportunity in education and public employment. And at the same time, provisions like Article 16, they allow for some special provisions to the people who have suffered historical injustice, such as OBCs, SCs, STs, and persons with disabilities, right? So there will be special provisions for these communities because they have suffered the historical injustice and they are also socially and educationally backward classes, right? So both Article 15 and Article 16, as part of right to equality, they talk about the affirmative action. They talk about the need for affirmative action. Now, apart from that, Article 15 clause 4, Article 15 clause 5, so they even empower the state to make special provisions for socially and educationally backward classes. So here OBCs, SCs, STs, so all these different communities forms part of the socially and educationally backward classes. And even Article 16 clause 4, it actually permits reservation in government jobs for backward classes which are underrepresented in the public services. And Article 16 clause of 4A and 4B, so they even extend reservations in promotion and carry forward of unfulfilled posts. Right, so these are 4 important provisions with respect to reservations for socially and educationally backward classes. So however, if you look at the reservation at the central level, so currently the reservation stands at 59.5%. It already exceeded the 50% ceiling set by the Supreme Court in Indira Saunai judgment. Now, out of 59.5% reservation, OBCs enjoy 27%, SCs enjoy 15%, STs enjoy 7.5%, and EWS enjoy 10% of the reservation. And apart from that, the persons with disabilities also enjoy a certain 2.5% of reservation as well. So therefore, all these provisions which aimed at achieving the affirmative action or correcting the historical injustice suffered by the socially and educationally backward classes. So these provisions actually form the backbone of reservations in India. Right, so it ensures that there are certain historically marginalized communities to have access to opportunities in education and employment. However, implementation of these provisions, especially in cases like Maratha reservation, so it has led to a complex legal and social debates and it often challenges the constitutional validity of such measures, because if the states provide reservation, so it breaches the cap of 50%, so therefore it violates the Supreme Court's judgment as well. So let's understand some landmark judgments in this context. So if we talk about some landmark judgments which specifically focuses on 50% cap on reservation, Balaji versus State of Mysore 1962 case. So this was the case that was first in this particular case, Supreme Court for the first time introduced 50% cap on reservations. Balaji versus State of Mysore. The second case was a State of Kerala versus N.M. Thomas 1975 case. Now in this case, the Supreme Court has recognized the need for substantive equality rather than the formal equality. So there is a need to differentiate between the formal equality and substantive equality. So formal equality, equality in literal sense, everyone are equal irrespective of their social status, economic status, educational status, everyone are being viewed as equals. However, if we talk about this substantive equality, so we'll be taking into consideration the historical injustice suffered by these marginalized sections of the society, and only then, so this is called as the substantive equality, right? Because there are certain communities who have suffered this historical injustice. So what you do, you provide affirmative action. You provide some welfare policies, welfare programs which specifically aimed at these marginalized sections of the society, and only then you would achieve the substantive equality. However, in 1992 Indira Sawhney judgment, so it upheld the OBC quota and it has enforced the 50% cap, introduced creamy layer for the other backward classes as well. However, in 2022 Janhit Abhiyan case, the Supreme Court has validated EWS quota and held that 50% cap applies only to the backward classes. And in fact, in Devendra Singh case, the Supreme Court has even suggested the creamy layer for scheduled caste and scheduled tribes. So these are some important and landmark cases that deals with reservation and 50% cap of reservation. So let's understand some issues with respect to unequal distribution of the benefits. We all knew about the Rohini Commission that has been appointed for the subcategorization of the OBCs. Because if we talk about the OBCs, so OBCs are not a one single caste group. There are thousands of castes within OBCs. And out of all those castes, there are only very few castes which are progressive. So therefore, this 27% of reservation has been given to the OBCs without any subcategorization. So therefore, the most progressive caste groups like Yadavs are mostly benefiting from this 27% reservation given to the OBCs. So in order to subcategorize the OBCs, Justice Rohini Commission has been appointed, and it has found that 97% of the OBC benefits are concentrated in just 25% of subcastes. And in fact, nearly 1,000 OBC communities, so they have a zero representation in jobs and education. So you can imagine that even though 27% of the reservation has been given to the OBCs, the benefits are not actually penetrated to some sections of the society within the OBCs, right? Because most of the benefits are taken by the progressive castes within the OBCs. And even in SCs and STs, benefits are often captured by the relatively advanced subgroups rather than all caste groups within the SCs and STs. And in fact, no creamy layer exclusion applies to SC and ST, leading to intra-group disparities as well. So overall, this raises serious issues within the reservation system, that can reservation truly uplift the most marginalized sections of the society? So that is a real question that we should address here. Now let's understand some arguments in favor of exceeding the 50% cap on reservation. Right? So can we really exceed the 50% cap of reservation? So there are some arguments which actually favor. Now one argument says that backward classes or the marginalized sections of the society in India, so they form the majority of India's population, so therefore it is a justifiable thing that the reservation should exceed the 50% quota. And apart from that, the social justice as a concept requires substantive equality, not a rigid formal equality. So I have just explained what exactly is a formal equality and substantive equality. Now here social justice actually requires substantive equality but not rigid and formal equality. Now in Tamil Nadu model, reservation beyond 50% exists without destabilizing the governance. Right, so in states like Tamil Nadu, so the reservation within the state is more than 50%, but it has not destabilized the governance in the state of Tamil Nadu. So therefore this is another strong argument in favor of exceeding the 50% cap of reservation. Now the caste census data would be out by 2027, and this caste census data may demand the recalibration of the quotas as well, because we would have a comprehensive caste data and the socio-economic background of the people. So therefore it may result in increasing demands for recalibration of the quotas. So therefore all these arguments that we are looking at, so they often form the basis for demands like Maratha reservation, which seeks to expand the scope of existing reservation policies. And in fact, the proponents of exceeding 50% of the quota of reservation, so they also argue that such expressions or such expansion of more than 50% of reservation are necessary to address the persistent educational backwardness and economic backwardness among certain communities. So there are some counter arguments to this as well. So if we talk about the counter arguments for exceeding the cap of 50% of the reservation, now Dr. B.R. Ambedkar, so he envisaged reservation as a minority safeguard but not a majority entitlement, and he also envisaged that the reservations should be a temporary measure, it should not be a long-term measure. And in fact, through reservation, merit would be diluted, because excessive reservation may reduce efficiency in the government services. But in order to become Vikasit Bharat, it is also very important that we should also emphasize or stress on merit as well. So in fact, Indira Sawhney judgment, so it fixed the reservation cap to 50% except in extraordinary circumstances with the strong data that demands need for reservation for a particular community. So therefore the arguments for 50% cap exceeding and against exceeding 50% cap, so they highlight the need for a balanced approach to reservation in India. So there's a need for balanced approach for reservation in India, considering both social justice and the administrative efficiency. So those all factors need to be taken into consideration. There is a need for a larger debate, and there is also a need for a multi-stakeholder think, so that an overall and a comprehensive solution can be arrived at on this issue. So the next important topic is GST Council recently approves 2-rate tax slab. So it is part of the larger GST reforms that the government has brought in. So let's understand about this GST Council reforms or GST reforms. So recently the GST Council in its 56th meeting, so it has approved 2-rate GST structure of 5% and 18% slabs, right? So this is a 2-rate tax slab, and that is going to be effective from September 22. Now apart from 5% and 18%, there are certain goods which are considered as a sin goods and luxury cars, for example alcohol, tobacco and pan masala, gutka and luxury cars. For them the GST would be 40% each, right? So the slab would be 40%, but except that there will be a 2 slab GST implementation from September 22. So this has been approved in the 56th GST Council meeting. Now, in fact, this GST reforms is considered as a significant policy reform because it aims at simplifying the taxation and also reducing the consumer burden as well. So let's understand some key highlights of the GST Council's decision. So if we talk about the GST Council's decision on reducing the taxes, or making only 2 slabs under GST, except the 40% slab for sin goods and luxury items. So 2 primary GST slabs, one is 5% slab and another is 18% slab. So this 2 slab GST rate replaced earlier existing 5 slabs GST rate. So earlier there were 5 slabs, and these 5 slabs come down to just 2 slabs as part of the larger GST reform. Now, apart from these 2 slabs, 40% is a special rate for certain items. Certain items like luxury cars, yachts, helicopters, tobacco products, for them 40% tariffs. Now, GST, goods and services tax. So goods and services tax is an indirect taxation reform in India. Right? So this is an indirect taxation reform in line with the theme called One Nation, One Tax. One Nation, One Tax. Right? So there will be no cascading effect of the taxes when the GST has been introduced. So it has been introduced in the year 2017. Now, common household goods such as soap, shampoo, toothpaste, bicycle, tableware, kitchenware, so they will move down to 5% from the higher brackets. So earlier there were some products within this category, so they were in the higher brackets. So from those higher brackets it will be moved down to the lower bracket. So what happens is that the prices will come down drastically. So declining prices actually means that the consumer demand will increase manifold. The consumer demand will increase manifold. The domestic consumption will also significantly increase. Increasing domestic consumption means that there will be substantial increase in the domestic manufacturing. Domestic manufacturing will be substantially increased. So therefore it will give a push to the economic growth. Consumption-led economic growth in India. Consumption-led economic growth in India, because India is a country with 1.4 billion people almost, right? So the 1.4 billion people can give a sustained push to grow Indian economy. Now, life insurance and health insurance policies shifted from 18% to 0%, so thereby overall reducing the financial burden on various sections of the society as well. And apart from that, there are 33 medicine which are considered as life-saving drugs or medicine: paneer, milk, Indian breads, and spectacles. So they will now attract 0% GST. Right, so this is very important and a very significant reform that the government has brought in. Right, so you can also see how the GST rates have been substantially reduced for number of products: daily essentials, healthcare, education, agriculture, automobiles. Right, so the GST rates have been substantially reduced. Now let's understand about this GST framework. What exactly is a GST framework? So as I've already told you that the GST framework has been introduced in the year 2017. So in line with the theme One Nation, One Tax, and it has subsumed all indirect taxes such as value added tax, excise duty, service tax, everything. And it has been administered by the GST Council, and this GST Council is chaired by Union Finance Minister with representatives from almost all states. So it has 4 rate structure, which is 5%, 12%, 18% and 28%. So therefore it has a 4 rate structure. So it has earlier created complications and inverted duty structures as well, having multiple tax slabs. So this, as part of the GST reform, so it has been reduced to 2 tax slabs only, 5% and 18%. Right, so this new GST tax reform aimed at tax rationalization, rate rationalization, and removal of duty inversion in textiles, fertilizers, and the cement as well. And a special compensation cess continues on certain products such as tobacco, pan masala, till repayment of center's borrowings to compensate the states. Right, so this is about the GST. And I have explained that the earlier multiple slabs were existing within the GST framework, and those multiple slabs were now made only just 2 slabs, except the 40% tax or GST on certain sin goods along with the luxury items. So that's all in this lecture, and thank you so much. So please subscribe our YouTube channel and also hit the like button. Thank you.